Hey future agents, and welcome back to the channel. I'm Cameron, and today we're diving into one of the most important and definitely most tested topics on the North Carolina real estate exam, contracts and closing. Let's walk through the offer to purchase and contract, often called the OPC, which is the standard sales contract used in residential real estate transactions in North Carolina. It was jointly developed by the North Carolina Association of Realtors and the North Carolina Bar Association. Most residential property transactions in North Carolina use this form. When we're talking about offers, contracts, and closings in North Carolina real estate, the most important thing to remember is that a contract is only binding when it is signed by all parties and acceptance has been communicated. The OPC serves as the formal written offer from a prospective buyer to a seller. It becomes a contract once the seller signs it, and that acceptance is communicated back to the buyer. Verbal agreements are not enforceable in real estate. Everything must be in writing. Now, when a buyer is ready to make an offer, they or their agent will fill out the OPC, stating the price, any contingencies, and the proposed terms. This initial document, once signed by the buyer, is a written offer. At that point, the buyer is the offerer and the seller is the offeree. If the seller accepts the offer without making any changes, they sign the same document and the contract becomes legally binding once that acceptance is communicated to the buyer. Communication can be through the agent, via call, email, or text, just as long as there's proof the buyer was notified of acceptance. If the seller doesn't agree to all the terms and wants to make changes, they must initial and date any revisions and also sign the contract. This creates a counteroffer, which legally becomes a new offer. Now the roles flip. The seller becomes the offerer and the buyer becomes the offeree. It's very important that licensees understand who the offerer and offeree are at each point in the negotiation. It shifts with each counteroffer. In a dual agency situation, where the same firm or agent represents both buyer and seller, acceptance is considered communicated once one party tells the dual agent they accept the other party's offer. Now let's talk about broker responsibilities. A broker must be competent to prepare a sales contract. This means they must be careful, accurate, and knowledgeable. If a broker prepares a contract poorly, they could be violating both agency duties and licensed law. They also must avoid giving legal advice, so while they can explain contract options and contingencies, anything beyond that should be referred to a licensed attorney. North Carolina brokers generally use the NCAR, NCBA jointly developed standard forms. These are legally vetted and widely accepted. The North Carolina Real Estate Commission doesn't create these forms, but it does require brokers to understand how to use them properly. Brokers can use pre-printed sales contract forms, but only if the forms require the broker to enter 19 specific pieces of information, things like legal description of the property, the price and type of payment, buyer and seller names, and so on. However, brokers cannot use forms that include pre-written language about broker commissions or any language that tries to release the broker from liability. If a buyer or seller wants to draft their own contract or modernize a standardized one, they can do so, or they can have an attorney do it on their behalf. Now let's go through the 4 basic stages of the North Carolina closing process. 1, preparation for closing. This includes inspections, finalizing financing, checking title, arranging insurance, and preparing documents. 2 is closing day. The buyer, seller, and other parties meet to sign everything. The buyer pays closing costs, the deed is signed, and ownership is officially transferred. Funding the transaction. After documents are signed, the buyer's lender releases the funds and the settlement agent records the deed. And finally, post-closing, final steps include issuing title insurance, transferring possession of the property, and wrapping up things like utilities. Now let's look at some of the most commonly used addenda that brokers might attach to the OPC to tailor it for specific situations. The additional provisions addendum, additional signatures addendum, backup contract addendum, used when a buyer wants to be in second position in case the primary contract falls through, FHA VA financing includes conditions for government-backed loans like mandatory appraisals or repair requirements. Lead-based paint, if it was built before 1978. Loan assumption addendum, used if the buyer is taking over the seller's existing mortgage. New construction addendum includes terms for properties under construction like specs, completion date, and warranties. HOA and condo disclosure addendum lists fees and rules for properties in a homeowners or condo association. Seller financing lays out the terms if the seller is acting as the lender. Short sale addendum and vacation rental addendum. Now, regarding contract procedures, even if a broker presents an offer orally, they still must deliver the written offer within 3 calendar days. Brokers should never assume they have authority to accept or reject offers on behalf of their client. Only the buyer or seller can do that. Only one contract must be signed by all parties to be binding, but copies must be given to all parties. And when it comes to sharing offer details, a broker must have the seller's permission to disclose other offers or acceptable terms. Shopping one buyer's offer to another without permission is prohibited. All offers, whether accepted or not, must be kept on file for 3 years. As for the settlement agent, the buyer usually picks them. This is often an attorney in North Carolina. The settlement agent handles the paperwork, disperses funds, and records the deeds. The settlement agent will need the full sales contract, contract information for all parties, lender details, inspection reports, a survey if available, and the insurance binder. Let's also talk about the buyer's due diligence process. This standard 2T contract is not contingent on getting a loan. If the buyer doesn't get financing by the end of the due diligence period, it's considered a breach of contract. Buyers usually get inspections during this period, everything from home and termite inspections to radon or water tests. They should also research HOA covenants, zoning restrictions, and get a survey. If the property has a septic system, buyers should review the permit and order a test. Repairs can be negotiated during due diligence, but must be finished before settlement. Right before closing, the title is examined to make sure it's clean, and if any defects are found, the seller must clear them. The buyer's lender will send the loan package to the settlement agent, and the agent will review the closing disclosure, which the lender must send the buyer 3 business days before the closing, under federal TRID laws. The buyer must bring certified funds to closing, either a bank check or a wire transfer, no cash or personal checks. Title insurance is also arranged at this time to protect the buyer and lender from future title disputes. Now let's define a few final terms. Settlement is the process of transferring ownership and finalizing the financial aspects of the sale. Settlement meeting is the actual event where parties sign documents and transfer funds. And closing is the completion of this process, when everything is recorded and the funds are dispersed. In North Carolina, closings typically happen with a settlement meeting, not an escrow process. The North Carolina Good Funds Settlement Act requires funds to be verified and deeds recorded before disbursement. After closing, the title is updated and liens are canceled and tax forms are completed. Brokers play a key role here too. They need to review the settlement statement for accuracy, verify any changes, and make sure all expenses are reflected, even if they were paid outside of closing. If the broker notices any mistakes, they must inform all parties, including the buyer, seller, lender, and settlement agent. Failing to ensure accuracy or delivery of this document can result in disciplinary action from the North Carolina Real Estate Commission. That's it in a nutshell, contracts and closings in North Carolina. If you enjoyed the video, please give it a like and subscribe, and we hope to see you in the next one. Cheers!